SJC-12809, Dale Young v. Contributory Retirement Appeal Board, and another.
Ms. Young, when you're ready.
Thank you. Good morning, and may it please the court. Dale Young, pro se appellant. So the issue before you is whether the lower court erred in upholding CRAB's April 2018 decision concerning my retirement benefits. I would submit that yes, the lower court did err because such decision was based on an error of law and not supported by substantial evidence. Now, the standard of review is well settled. Courts are not bound by a CRAB decision, although CRAB is given the authority to interpret Chapter 32, and their decisions are given some weight. Courts can reverse a CRAB decision if it is based on an error of law and not supported by substantial evidence. I'm going to refer to this as the CRAB decision just for sake of brevity. So that decision held that during my years as a contract employee, I did not meet the statutory definition of employee, and therefore my compensation was not regular compensation and could not be used in calculating my retirement benefits. I request this court to reverse the CRAB decision and order the State Board of Retirement as co-defendant to recalculate the retirement benefits, taking into account my compensation as a contract employee.
When you were hired, did you understand you weren't getting health care and you weren't getting retirement? Was that all explained to you?
Yes, I was explained as a contract employee.
So you understood your status when you were hired?
Yes, I did. The dispute before us is primarily one of statutory interpretation, looking at Chapter 32 and 29. And there are certain facts of my retirement that are not in dispute. I retired effective July 2010. I was approved for 21 years of service. 4 of those years were as a contract employee. Per Chapter 32, Section 41S, we can buy back 4 years of our contract time and establish it as years of retirement service. So I paid $40,000 to the State Board of Retirement to establish those 4 years. Now, I worked 10 years, actually, as a contract employee from 1998 to 2008, but the law allowed me to buy back just the 4 years. So I basically lost 6 years of retirement credit, and yes, I was aware that as a contract employee, I was not entitled to the benefits.
Can you tell me what the 21 years are? So 4 of them were bought back, but can you just tell me you started when? And because I know you were in and out.
I had a lengthy history with the Commonwealth. I started in 1979 working for the State Department of Public Health, worked there for 3 years. I left state employment. I then worked for DEP from about 1986 to 1998. And then for EOEA from 1998 to 2010.
But of those, how many?
So that's approximately 26 years.
Okay.
But because
26 years total, but 10 years as a contract employee?
yes.
And when you switch back and forth from regular employment to contract employment, did your salary go down when you became a regular employee?
Could you repeat that? When I switched from a contract employee back to?
Yeah,
Yes, it did.
I mean, you're
Yes.
a very sophisticated state employee. You understand a lot of how this works, right? So did you take pay cuts when you moved on to regular employment, for example?
I did.
So you understood there's a trade-off in state government, right? You get either the higher salary without these benefits, or you get the lower salary with the benefits. It's understood as part of the employment relationship, isn't it?
Well, it's understood that as a contract employee, you don't have the same rights as a member in service.
Mm-hmm.
And you don't have sick time, vacation time, health insurance.
Right.
You don't get the step raises. So in actuality, it's not really, it doesn't equate at the end to higher benefits.
So I'm not saying it's better or worse, I'm just saying it's different. And it's sort of it's understood it's different, too.
Yes, it is different. And I think my point I'm trying to make, though, yes, I knew I was a contract employee, but I think in looking at the evidence and the statutory language, I still met the definition of employee per Chapter 32.
Although, is there a difference between a regular employee and a sort of a special or a contract employee?
Well, they're authorized positions, and they're designated by various contract codes.
I'm just focused on the statute too, right? So the statute, the termination allowance is calculated based on an employee's, quote, average annual rate of regular compensation.
Correct.
And then an employee is defined as any person who is employed or appointed, stated thereof, and who is regularly and permanently employed in such service, and excluding any person whose compensation for services rendered to the Commonwealth is derived from the subsidiary account.
Right.
So we also have to take into account this idea of a regular employee, right?
Yes.
Regular compensation.
Yes, and I will get into that. Dallas' decision actually found that I was sufficiently regularly and permanently employed because I was employed for 10 years without break as a contract employee.
Were you paid by contracts? Did you have a contract each time?
Yes,
And how long were those contracts?
1 year.
How long?
1 year per,
So each time you had a 1-year contract,
yes.
right? Okay.
Renewed for 10 years, sequential years with no break in employment.
Right, and so.
So Dallas saw this.
So just so I
I'm sorry.
understand, because, so each year you're on a contract.
Yes.
And did that contract describe you as a regular employee, or how did it describe you?
It described me as a contract employee. And my point of my argument is that even though I was classified as a contract employee, I should not have been excluded from the definition of employee in Chapter 32 because I was not paid from the 03 subsidiary account. And my employment was sufficiently regular and permanent.
When you were paid, were you also, did you know were you on a grant? How were you paid?
I was paid through the capital bond fund for certain years, a trust fund for certain years.
So you're paid on a capital bond and you're not in the, the NN account for capital expenses?
No, I was in the CC account.
So you're always in the CC account,
Yes.
even though you're being paid off of a capital bond account?
Yes. Yes. And if I have an opportunity, I'd like to walk you
Go ahead.
through some of the evidence. So as you pointed out, my pension was based on 1/3 of the highest 3-year average of my regular compensation. CRAB ruled that as a contract employee, I did not earn regular compensation. Therefore, I could not use my contract employee salary for purposes of retirement benefits. And as you pointed out, the relevant language of regular compensation and employee. And so let me just say that at the core of CRAB's decision is their foundation that I was paid out of this 03 subsidiary account, which would exclude me from the definition of employee. And, but evidence shows that in fact, I was paid from an account called the CC account. And I realize this goes into the weeds of the state budgetary system and talking about accounts, but I will, and I will try to go through the details quickly, but it's important to understand what this 03 account means in the statute. We have the 03 account, we have the new CC account from which I was paid, we have the HH account and the NN accounts, which were for consultants. And I think the evidence shows that I was not paid from the 03 account, and I should not have been excluded from the definition of employee, and I was instead paid from this CC account. And CRAB in its decision identified the April 1990 Expenditure Classification Handbook, and this handbook showed that the 03 account was eliminated in 1990 and new accounts were established, including the CC account from which I was paid. And that was an account for special employees. This is how it is described by the Office of the Comptroller, a special employee who is paid on a temporary basis through contracts. And the account is listed as employee compensation. Now, the HH account is listed as consultant services. And I think what's important is the history of the O3 account. That account was used for consultants, and the amicus brief went through the legislative history of the use of the O3 account, clearly for consultants, not someone who was categorized as a contract employee as I was. And CRAB fails to acknowledge that the O3 account was eliminated, and CRAB continues to say that the CC account was really just a subpart of the O3 account, and I say this is a false assertion because, as I said, the O3 account was specifically for consultants. And in 1990, the Commonwealth created new accounts, the CC account for employee compensation and the HH account for consultants. So I would contend that HH would be considered a formerly O3 account. And if you look at several documents that I presented, there's a November 2005 Office of Comptroller report, which draws this distinction, and saying that contract employees are not consultants. They are categorized under CC, whereas consultants are non-employees, and they are paid from the HH and NN accounts. And we also have the February 2010 State Auditor's Report, which I point to you some very important language. And in this, they said that contract employees are considered temporary employees. And they go on to say, independent contractors, that is consultants, do not have an employer-employee relationship with the Commonwealth, but provide their specialized services under Object Code HH. These individuals were previously described as O3 consultants. Contract employees, on the other hand, have an employer-employee relationship with the Commonwealth and are funded under Object Code CC. What's important is that contract employees are not consultants. They were not paid under, they should not be considered as paid under the O3 account. The terms are not interchangeable. They are very distinctly separated out by the Office of the Comptroller and the Auditor, and the terms are not interchangeable. And I also point you to some facts. CRAB, the only evidence that CRAB provided that I was paid from this O3 account was a single handwritten asterisk notation written at the bottom of a form which said that O3 contractor prior to 2008. There's no initial to that notation. It's handwritten. I have no idea who wrote the notation. And the Commonwealth, and I have to point this out, the Commonwealth stated in its filings with this court, to the extent the plaintiff argues this form was invalid, that argument was not raised before CRAB or in Superior Court and is therefore waived. Let me just say, for clarity, and I think I put this in my reply brief, that I certainly objected to this notation in my DALA hearing, as well as in my filings with Superior Court and the Appeals Court. So I have to say I was surprised by the mischaracterization of the record by the Commonwealth.
I'm confused of what you're talking about. Are you talking about the 1990 expenditure classification schedule revisions? Is that what you're talking about? Because that has a, that's not a handwritten, that's a form, right? That has.
Oh, the form is a,
And isn't that
it's
the,
a state retirement form, and it's,
well, it says crosswalk of fiscal year 1990 subsidiaries to fiscal year 91 subsidiaries. I thought that's from, this is from a comptroller document, right? It's not
that
handwritten.
crosswalk with the chart.
And isn't that the best contemporary evidence
Well-
of what the conversion of 03
Well,
to C? Yeah, go ahead.
In addition to that, there's the actual expenditure classification handbook, which really needs to be looked at. This is just the one that you're referring to as a memo. The handbook was issued by the comptroller, and the amicus brief actually included several pages from that handbook.
The document you want me to look at say that CC is not 03?
The document says that CC account are special employees,
Right, but
and their
there's a,
funding is considered employee compensation.
right, but there's a difference between special employees and regular employees, right?
Yes, yes, there could be. I mean, you have to look at the totality of the circumstances of the employment. And in my case, I didn't work 1 or 2 years. I worked 10 years with sequential one-year contracts. And even the Commonwealth in its SMART plan, which talks about the alternative retirement for employees such as myself, says that you are not temporary if you have been employed for more than 2 years under sequential contracts. And I think that's a really important point in who is temporary. You know, what does temporary mean? And they clearly stated that if you work sequential contracts for more than 2 years, you are not a temporary employee. And I see.
I see your time is up, but I've got one question with regard to your contract. Does your contract give you an annual salary, or is it a per diem?
It's an annual salary paid through regular means. I received a paycheck just like other employees.
But I mean, I'm trying to figure out, because you were not paid if you were sick, correct?
Correct.
And so, does the annual salary contingent upon your working a certain number of days? I'm just trying
A
to figure
certain
out.
number of hours.
Certain number of hours. So basically, it said you were contracted to work during the course of 1 year, say 2,000 hours, and for the 2,000 hours, you get paid X. And if you were to work less than that, it would
Well, it was also based on an hourly rate, too.
okay, so if you worked less than the total, your salary would be diminished.
Right.
And if you worked, were you allowed to work more than those hours? Would you be paid
No,
for?
no.
Okay, so you were.
And what's
you-
important
you-
is I
you-
was
you- you
paid
were
on a
capped.
regular recurrent basis. I was given an employee ID number. I was paid according to the same payroll system that regular employees were paid. And it's important to look at that definition of regular employment, that it was not temporary. I was not a temporary employee. I met the statutory definition of employee, and I think that's really important for the court to understand. And I'm sorry I didn't get a chance to go through all that I had prepared. If I could just take one more minute of time.
One more minute.
Okay. All right, thank you. Some of the cases that CRAB relies on in its case, they are not relevant to my situation. They are independent consultants, obviously not employees. Chapter 29, Section 29A defines consultants as non-employees paid from the O3 account. These are not contract employees. They are, and again, these are distinct terms with very specific meanings.
Okay, I think your time is up.
Okay, thank you.
Thank
And
you
if
so
I
much.
could just ask the court, if you could please issue a final decision in this matter. I've waited 8 years for the agencies to make their decision.
Have no choice. We have to issue a final decision.
You did, okay, excellent. Thank you, and thank you for your attention.
Thank you. Mr. Jarrett.
Chief Justice and Associate Justices, may it please the court. Justice Kafker, there's no question that the Commonwealth can hire contract employees, but what has to be viewed here is it has to be viewed on a temporal timeline, because as a contract employee moves down the timeline, they encounter effectively what are two safety nets for purposes of federal retirement benefits as well as state retirement benefits. The first is at a 6-month point in time. Under board policy, even temporary employees are entitled to membership in the state retirement system. And that's 941 CMR 2.03(1)C. As they move.
941 CMR what?
941 CMR 2.03(1)C. And as they move past that, there's yet another retirement safety net. It's a federal safety net. It was established.
So I'm confused. So that regulation says that if you're on a contract, you're a 1-year contract employee, and you get to the 6-month and 1 day, you now become a regular employee entitled to all the retirement benefits?
Well,
So you've,
that is our position, and that position is consistent
when I
with.
read that regulation, is that going to be that express and say that it overrides? Because you've just dramatically, anyone who's worked for the state government is now a regular employee if their contract lasted more than 6 months? Don't almost all of these contract employees have one-year contracts?
Yes.
So you've just transformed the retirement system based on that language and that regulation?
No, the law exists.
Well,
And since 1974, retirement board policy has been that an employee is entitled, after 6 months, to be a member of the state retirement system, and that they shall not have to ask to be included. The conundrum is...
But again, I just want to make sure, because, I mean, we're going to go back and read this stuff. So it's 6 months and 1 day.
Right.
Everybody is a regular employee of the system. By the way, does that mean we've misclassified, hundreds of thousands of employees over the retirement system? I'm just trying to understand what the effect of your ruling is right now.
Well, it's not hundreds of thousands, but it probably is over 10,000 individuals that have worked on these contracts. As they hit the 6-month mark, yes, they're entitled to state retirement benefits. That's not the same thing as saying that they're entitled to health benefits. It's not the same thing as saying that they're entitled to vacation days. But under board policy since 1974, yes, they are entitled. And no, they haven't received it. And what we're presenting in the amicus brief is a novel concept. It's a novel argument. It's complicated. This retirement system is highly complex. Chapter 32 is obviously inartfully drafted. There are some problems. But there's the two time frames. It's also federal law. So as you reach the 2-year point, you pass this other threshold, and under federal retirement law, you are entitled to not be seen as a temporary employee anymore. Federal law mandates this macro approach where you have to string together sequential contracts and ultimately view them stepping back and saying, what is the overall time frame? And just looking at the definitions of what is temporary, it would not be credible for any person to suggest that 10 years is a temporary time frame or a short time frame. We don't really equitably look at this as 1-year contract 10 times. Instead, it's a 10-year time frame because there's no break. And so ultimately, that's our position of how the court should view this. And retirement benefits are deeply important. This court said so in the opinion of the justices in 1973. State workers look at these benefits as deferred compensation for state service. And although the contract...
By the way, so it doesn't matter if you're a CC, an HH, a JJ, or an NN?
It matters a great deal.
Well,
There's
why-
a big difference between those categories.
Well,
So-
but I thought you said if you work 6 months in a day, you're automatically entitled to retirement. I assume that would apply across the board all these.
No, it doesn't. This case really boils down to a confusion and a conundrum over what is the definition, what's the meaning of an employee. So that...
It's really different. It's what did the legislature mean in 1973 when it carved out that exclusion? Isn't that what we're asked to determine?
Yes, and what it meant, it was very clear. Rolling the clock all the way back to 1973, this idea of a contract employee that would serve 10 years, 27 years, didn't really exist. So the point of the 1973 change was a product of a legislative...
But we do know there was a lot of abuse in 1973. We have people, don't we have, I mean, I thought that's what you were going to talk about, the legislative history from 1973. What is the legislative history? What was happening in 1973, and what did the legislature do to fix it?
Yeah, so the 03 account has existed since 1949, at least, and maybe even older. And it was designed to allow the Commonwealth to retain the services of independent contractor consultants so that they would come in for a period of time. But these people are not employees. That's the difference. In 1973, the State Legislative Bureau and Government Oversight studied the problem, and they found a series of abuses. The abuses they found were that independent contractors who theoretically could run their own business on the side, that they were getting state benefits, including retirement benefits. And the Bureau said this is absolutely inappropriate. These are not state employees. Retirement benefits are designed to be only for state employees. And there was this,
Regular state employees, right?
regular state employee. But ultimately,
People
it's
who are being paid for by the state budget, that they could project how much they were going to cost and how much their retirement costs were going to be. Instead, a bunch of people were getting in on these contracts and becoming eligible for the retirement system. And the legislature put an iron curtain in place, right? Said anyone paid off these 03 accounts are not eligible, right?
correct. And
Regardless of what they were doing.
that's correct, and we agree with that change. We don't suggest that the state should now be offering retirement benefits to independent contractors. The 03 code always applied to independent contractors, but the state the legislature did not say or intend in 1973 to exclude employees. What ended up happening is you take the term employee and you sort of divide it, and then you have this sort of two classes of employees. One is a so-called regular employee, and then the other is a contract employee. But the state legislature didn't have that concept in mind in 1973 because, as far as we know, the term didn't develop until after the OBRA law in 1990. What you see is a state grappling with trying to get services done for public service, but ultimately not having a sufficient number of regular jobs, posted jobs, to be able to do that. So the agencies use the 03 account, or also the CC account, which ultimately developed later after the 1990 handbook, and it started using those positions functionally as substitutes for so-called regular state positions. But this court can decide this case by looking at the definition and the clause that was inserted in 1973 and looking literally at, it states, if your compensation derives from the 03 account, then you cannot be considered an employee. The point was to block independent contractors. It's a vestige that has never been amended. We haven't used the 03 code in the Commonwealth since 1990.
It wasn't really to block independent contractors, it was to block the use of this terminology to, it was a budgeting device, wasn't it? It's not, the Commonwealth's perfectly happy having independent contractors if they're really independent contractors. What it didn't want is people being hired through monies being devoted to that, right? It was a different problem.
I would respectfully disagree. I don't think that the Commonwealth has an interest.
It would help me if you point me to something in the legislative history that supports your position.
Well, my position, I think, is supported by the 1973 report, which focuses on, and in multiple instances there are, in all caps, it says that this 03 account was designed to apply only to non-employees. And they say that a number of times, and we have it in the
Right, but isn't the logical meaning is this 03 account was meant for independent contractors. We don't want you, we don't want the practice going on, which is this hiring of people using these 03 accounts. But again, we can read it, we'll figure it out.
Okay,
Okay, thank you.
thank you.
Ms. Troy?
Good morning, Your Honors. May it please the Court. My name is Melinda Troy, and I'm here on behalf of the State Board of Retirement. Ms. Young was not an employee during the period of time that she was rendering contract service, and therefore her gross pay was properly not considered to be regular compensation for retirement purposes.
Wasn't an employee at all? Was she an independent contractor?
She has never alleged that she was an independent contractor. My understanding of her argument is that she always has alleged that she was a CC.
A contract employee?
Yes, especially, I
No,
believe
but she
that-
wasn't an employee. She was not a regular employee is what you're saying.
Exactly, and for retirement purposes, she is not an employee who is entitled to use her regular compensation to calculate her retirement benefits. And
So but we're kind of in a betwixt and between state, right? She's I understand she's not a regular employee, but she's a contract employee, and that wasn't really what, I can't figure out what the 03 meant in 1973. That's, the thing that gets a little tricky here is, she's not really an independent contractor, right? She wouldn't meet any of our current definitions of an independent contractor. She's really this kind of contract, year-to-year contract employee, which is not a regular, she's different from a regular state employee, but she's also kind of, she's not what we consider an independent contractor in at least 2020 terminology, maybe in 1973, but in 2020, she's not an independent contractor, right?
I would agree with that, Your Honor. I don't understand her to be arguing that she was an independent contractor.
Well, I think she's saying that 03 was only meant to apply to independent contractors, and because she's not an independent contractor, she blurs into what, you know, she's an employee of some kind. Whether she's a regular employee is really what we're trying to determine.
Right, she's not an employee. It would be the board's position that she's not an employee for retirement purposes.
Right, but is it illegal to do what you're doing? That's what I'm trying to understand. Does it violate any laws for her to be, we have a lot of fights about whether someone's an independent contractor or an employee, right? She's not an employee, she's not a regular employee for retirement purposes, nor is she an independent contractor under the law. Just trying to, is that okay?
For retirement purposes, it would be the definition of employee in Chapter 32 that controls. And she doesn't meet that definition because she was not regularly and permanently employed.
Does that violate any federal retirement laws? Your brother just argued that once you hit 6 months, your regulations make her a regular employee. I don't know where he comes up with that, but why don't you address that for a second?
Certainly. So my best understanding of that is that perhaps he's looking at the 1974 policy. My understanding of the practice at that time was that employees were considered to be what we would now refer to as probationary for a period of 6 months. I can tell you that now regular and permanent employees are enrolled immediately in the retirement system. But in earlier years, there were some employees who had a period of probationary time.
So there isn't any current regulation that makes someone eligible for retirement who's a contract employee after 6 months?
No, Your Honor, there is not. So right now, anyone who is regularly and permanently employed is enrolled in the retirement system from the day that they are hired.
Now, the statute, the definition of employee, I know uses the term regularly and permanent employed, but it also says, shall mean any person, whether employed or appointed for a stated term or otherwise. She was employed for a stated term of 1 year. So what do we do with that language?
So, Your Honor, I believe that that language also refers to, shortly around, in that same subsection of Section 1, it refers to employees of the general court. So it could also refer to someone who is appointed to a position for a stated term, as opposed to a contract employee who's given separate individual contracts for a period of years.
Whether employed or appointed, so it certainly addresses being employed for a stated term.
It could also apply to employees of the general court because they're elected, right? So they're elected for a term.
Okay, put aside the elected. I'm referring to the employed for a stated term. That's in the statute. What meaning do you give to being employed for a stated term?
I would say, Your Honor, that this particular employee's regular compensation was derived from an 03 account, and therefore she's excluded under a separate
Oh, I know you. I mean,
portion of
that's
Section 1.
but the 03 account is independent contractor. I mean, in 1973, were there contract employees?
I don't know, Your Honor.
Doesn't it matter in terms of what the legislature intended?
I don't think that it does, Your Honor, because the Crabb decision is quite clear in its description of how, with the May 1990 expenditure classification handbook, the designation of 03 for this purpose transitioned into the use of letter designations for contract employees, thus excluding them from participation in the retirement system.
But the only letters that relate to an independent contractor, I think, is the LL, is it?
It might be HH, Your Honor?
H. She's not an independent contractor. She's an employee.
She's not, but there are actually several letter designations that are discussed in the CRAB decision that JJ and N, and her argument has always been that she has been a CC
Right.
or a
and-
special
and-
employee.
And isn't she a special employee, a contract employee for 1 year? Isn't that what she is?
Well, even if she is, Your Honor, that's a derivative, that CRAB properly held that that's a derivative account from the 03 account, and that she's excluded from being an employee for retirement purposes.
Now, should we be concerned by the fact that if any private employee tried to do this, we would say she's an employee and it's illegal?
I don't think so, Your Honor, because with respect to the retirement side of things, which is all I can really speak to, the legislature has made it clear that for retirement purposes, although you cannot use your regular compensation to be included, this as regular compensation to be included in the calculation of your retirement benefits, you are permitted under Section 401S, which was just enacted in 2006, to buy up to 4 years of contract service. So to the extent that the legislature has addressed some limited retirement benefit to be available to this class of individuals, they've spoken that you're entitled to purchase some service and add to your years of service, as Ms. Young did here, but you're not entitled under the Leary case to use the compensation that you earned as regular compensation for retirement purposes.
Is the
How
case,
How does the retirement, so for these, you may not know this, but I'm trying to understand this, because is it illegal in the private sector I understand there are rules about workers' compensation and other things about employees, but is it illegal for retirement purposes to draw this distinction, to have temporary employees or contract employees not eligible for retirement benefits, or you just don't know the answer to that?
I don't know the answer insofar as the private sector, Your Honor.
Okay.
Sorry, you cited a case, the Leader case,
I'm sorry, the Leary case, Leary. It's in my brief?
1995.
Yes.
And you're saying that that's the answer to this question?
Well, I think that it's one case, admittedly, it's under a different provision of the statute under which someone buys back creditable service. But that individual had also argued that the pay that he earned during his out-of-state teaching should be considered regular compensation for retirement
Oh,
purposes.
but that's out-of-state teaching. That's not somebody who was working within Massachusetts.
That's true, Your Honor.
What's the effect of this? Say you lose. How many thousands of employees are we dealing with here?
I would say that it definitely would be thousands of employees. I
By
don't
the way,
have,
would it be every employee who's alive today? Because can't you buy back service? So say someone worked in 1965 as one of these employees or some really long period of time. Could you buy back your four most expensive, your four most lucrative contract years? Are we talking about 40 years of all the employees in the state who were in these 03 categories?
well, I think, Your Honor, the implications would be if the court were to somehow conclude that Ms. Young were an employee for retirement purposes, is
Or
that
how
your
about
question?
his interpretation, which applies to the NNs and the HHs and everybody else? How many people are we talking about here?
It would be many, many thousands, Your Honor, and it would have implications insofar as membership dates in the retirement system. The contribution rate that one pays into the system is driven by your membership dates. So potentially individuals could come to the board and say, I'm entitled to an earlier membership date because my contract service preceded my regular and permanent employment. So it would have implications insofar as the contribution rates. It would essentially, Your Honor, render 401S a nullity because then someone could arguably say, I was an employee, I was a contract employee for any number of years greater than 4, right?
Right.
And they would have an unlimited opportunity potentially to buy back that time, which would render 401S entirely superfluous.
Can I ask another question? In 1973, I'm trying to identify what was going on in 1973, because there were people like the plaintiff here in 1973, I believe. They were people being paid off of these kinds of 03 accounts, even though they weren't regular employees, right? That's what the legislature discovers, you've got all these people off budget, right? Is that what they were dealing with in 1973? What was, I'm trying to conceptualize the abuse in 1973 that they were trying to deal with. It wasn't sort of this independent contractor employee distinction that we're dealing with in our heads in 2020. They were dealing with a different problem, weren't they?
I think so, Your Honor. And to your comment or question about whether it's abusive, I would say, in fact, that it is not. It's someone could make a choice, in fact, to take a position.
Well, the
as a
legislature
contractor.
didn't like it, right? In 1973, the legislature did not like the fact that people in these contract accounts were becoming regular employees and they entitled to retirement benefits, right? That's why they wrote that that statutory provision, right?
I can't exactly speak for the legislature, but I do know that they excluded people paid from that derivative account in 2003 from the definition of employee.
What were people in that account? Do you know who they were? Were they people like the plaintiff here, or were they just pure independent contractors? Who were they?
I don't know back in 1973 who
We don't
they
have
were.
legislative history that's going to give us a better sense of that?
Not that I'm aware of, Your Honor.
Okay.
All right, so help me out here. Any person whose compensation for service rendered to the Commonwealth is derived from a subsidiary account, meaning an 03 account, they're excluded. We're sitting down, other than Krebs saying that this new designation falls within what would be 03 and this one doesn't, what do we look to?
So, Your Honor, there's portions of the expenditure classification handbook that are in the
The one
record.
thing is the handbook. Okay, what else?
And the other thing is the other
Legislative
substantive.
history, right, that
The-
Justice Kafka was just talking about.
Exactly.
What
And
else?
also, there is some discussion in the Crab decisions cited at footnote 28 in the Crab decision of the legislative history, the history of the transition from the 03 account to the accounts designated by letter. And that was an accounting mechanism. And what the Commonwealth did was they wanted to make sure that they could properly account for Commonwealth expenditures. They wanted to know where their money was going and who was being paid under what account. So as a matter of administrative efficiency, the Comptroller's office, it is my understanding, transitioned to those letter designations, which are also derivative of the 03 account.
So pragmatically, she gets her pension is based on her 3 most recent years of service or 3 top years?
It's the 3 highest, whether or not they're consecutive. So
Okay,
in Ms.
so-
Young's case,
So she
her-
gets 2009 and 2010,
yes, Your Honor,
then she has to go back,
to around 1998, Your Honor, is
so
the.
she has to go back more than 10 years
Yes.
because you basically hired her on, because the state hired her on 1-year contracts for 10 years.
Exactly. So that's the last time that she was a member of the retirement system, that 3rd year comes from around 1998. And in her role as a contractor, her last 2 years, she was earning between $87,000 and $89,000. When she became a member of the retirement system in 2008 to 2010, her compensation was $80,000. So she's arguing that she should be entitled to use that higher amount.
Are the handbooks in the record appendix?
There are portions of the handbook in the record appendix that are part of the record that Ms. Young submitted. The entire expenditure classification handbook is actually attached to the amicus brief as well.
And as a contract employee, you only get paid for when you work, correct?
That's my understanding, Your Honor, yes.
Out sick for a month, you don't get paid for that month.
My understanding,
Unless you
I
make
guess
up
it would
the
depend on
hours.
the terms of the contract, Your Honor. So that would be a matter between the employee and the employing agency.
And do we have her contracts here as part of the record, do you know?
Her contracts are not part of the record.
Not part of the record. Okay. All right, thank you.
Thank you, Your Honors.